Sarah Aziz, 3 Lancelot Drive. I'm here to speak about the superintendent evaluation which is on the agenda. It has come to my attention that the contract of acting superintendent Sherry Shanley appears to violate state law because it is missing a material clause. According to NJ statute, quote unquote, any contract entered into pursuant to NJSA 18A:17-15 shall provide for an evaluation pursuant to this section and may provide for an additional evaluation criteria or procedures which shall not be inconsistent with the regulations of the state board. In other words, a valid superintendent contract would contain a specific section addressing the superintendent evaluation. There is no such clause in Ms. Shanley's contract, whereas the contract of former superintendent Dr. Dory Alvick required that she be evaluated after 120 days after the execution of her contract. However, Ms. Shanley's contract does not contain the legal requirement that she be evaluated at all, and her contract was extended without an evaluation. The superintendent should be evaluated based on whether he or she met district goals, and these goals are typically published online. However, the acting superintendent and the Monroe Township Board of Education never developed district goals for the 2021-2022 school year. Even if the board initiated some type of evaluation at this point, it would not be sufficient because it would not meet the state standards and contract law. Additionally, without the provision for a superintendent evaluation in Shanley's contract, this means the board does not have to evaluate her using state-approved standards. This is another violation of New Jersey Statute 18A:17-20.3. It says, quote unquote, every local board of education having a superintendent shall evaluate the performance of the superintendent at least once a year. Each evaluation shall be in writing, a copy shall be provided to the superintendent, and the superintendent and the board shall meet to discuss the findings. The evaluation shall be based on the goals and objectives of the district and the responsibilities of the superintendent. The contracts of both former superintendents, Dr. Alvick and Mr. Goodall, both refer specifically to consideration and includes a basis upon which they get evaluated. Quote unquote, consideration is the backbone of a contract. It means that each party must provide something of value to the other party as designated by the contract terms. Without consideration, a contract is not binding. Shanley's contract, which has no end date, does not include any reference to her evaluation, therefore implying that there's no criteria that she needs to abide by in order to get paid and renewed. Shanley is not contractually obligated to provide anything of value to the district because the contract does not mention the word consideration. There's no consideration from Shanley, yet taxpayers have to foot the bill for her compensation and benefits package that cost $254,000. Ms. Shanley is contractually unaccountable, and therefore this contract appears to violate both New Jersey law and general contractual principles. Also, the contract makes it clear that tuition reimbursement is contingent upon the acquisition of a doctoral degree. Given that there's no evidence that Ms. Shanley has achieved a doctorate or is even pursuing one now, will the board demand that she reimburse taxpayers for the $38,000 that she's collected in tuition reimbursement over the past 20 years? This contract precludes the possibility of a just and fair superintendent evaluation and superintendent search. How does someone so poorly qualified compete with qualified candidates with legitimate evaluations? According to transcripts of the board member training released from the NJSBA, it's clear that the only board members who received thorough training on superintendent evaluations are Paul Rudsky and Michelle Arminio, both of whom did not vote to extend Ms. Shanley's contract. The remaining board members received the bare minimum of this training and have endeavored to appoint Ms. Shanley permanent superintendent against the direction of the New Jersey Department of Education, despite the vocal and growing community outcry. Again, I ask, how can the board justify their decisions?
I'm a certified board member. Why not?
Great job, Karen.
Thank you. Great job, Karen.
Thank you.
False news.
Yes, Mr. Gagliardi, can you please address the many falsities of those comments?
If I may, Madam President, I'll just pick a few. So were I a member of the board or the public, I would ask, how could it be that an attorney who's been representing school boards for 30 years and the Department of Education, which approved Ms. Shanley's contract, submit to the board for consideration a contract that has all of these legal flaws? And the answer is none of what you heard applies. The reason none of what you heard applies is because what you heard applies to the contract of a permanent superintendent. So if, for example, we went through the section of Title 18A that was mentioned, you would see that in order for the contract to be lawful, it has to be of duration no less than 3 and no more than 5 years. Well, this contract obviously just goes a couple months at a time. How could that be? And that's because none of what you heard applies. It applies to permanent superintendent contracts. So the reason this contract was submitted to the state for approval and got approved is because it's not a superintendent's contract. It's a contract for an acting superintendent. So you can't, for example, there was a reference made to setting annual goals. If a contract is 3 months in length, how would you set annual goals? So there are criteria for superintendent's contracts, and the criteria you heard apply to a superintendent's contract, but not to this contract. So the reason that this was submitted to the board and to the county and to the Department of Education, and it was approved repeatedly, is because none of what you heard applies to this contract.